years, the AFRINIC saga has been framed as a clash between good and evil, a proud African institution under siege. A foreign company, Cloud Innovation, portrayed as the antagonist, and its founder Lu Hen painted as the opportunistic outsider determined to bring AFRINIC to its knees. The media called it a cyber land grab, a battle for Africa's internet sovereignty. But a recently uncovered engagement letter suggests a different truth. It was far less ideological and far more self-serving. The road, it turns out, was not coming from outside. It was deeply rooted within AFRINIC itself. Cloud Innovation had been one of AFRINIC's largest members. Its IP address allocation, although frequently questioned, had passed some of the most rigorous scrutiny ever applied by any regional internet registry. Still in 2019, AFRINIC began legal actions, accusing Cloud Innovation of policy violations, namely allocating IPs to entities outside Africa. But AFRINIC's own policies did not prohibit out-of-region usage. Courts sided with Cloud Innovation multiple times. Injunctions were granted, membership terminates blocked it. Even AFRINIC's own CEO Eddie Kaihora was suspended by court, ordered for violating bylaws. Yet the lawsuits continued, over 50 of them dragging on for years. Why? A newly revealed letter provides an explanation. In October 2021, AFRINIC signed an engagement agreement with C&A Law. The firm was headed by Going Sami-Chinian, a former barrister who had been convicted by conspiracy to export foreign currency, struck off the roll and barred from legal practice. Despite this, AFRINIC authorized C&A Law to handle its lawsuits. 12 cases, to be exact, 9 of which were against Cloud Innovation. The fee, a flat rate of $1,000 per hour, plus unlimited disbursement for printing, costs, travel, and administrative expenses, with no itemization, no limits, no caps. The work itself, not done by C&A Law. They subcontracted it to Anwar Mullen, a senior counsel who, according to later Supreme Court rulings, had no legal authority to represent AFRINIC. By 2023, AFRINIC's legal expenses had ballooned to over $10 million. One would expect that such irregularities would have raised alarms, but they're small. Going Sami-Chinian's wife, Prabdevanandam Chinian, holds the position of Registrar of Companies in Mauritius. The office is responsible for maintaining the official company records, despite court rulings that multiple AFRINIC directors had no legal standings. Their names remained on the company register. Some of these individuals continued acting on AFRINIC's behalf in court. Why were they not removed? The conflict of interest here is more than troubling. It's systematic. AFRINIC's leadership never sought an out-of-court resolution. They pressed on with claims that judges repeatedly dismissed. Instead of cutting losses, they filed procedural objections, delayed hearings, and prolonged litigation. Each step added to the legal bill. A strategy that, in hindsight, benefited few, but enriched the lawyers and other individuals involved. Even when AFRINIC lost major court battles, the official message internally was, "We are winning." This distorted narrative sustained the legal momentum and the invoices. Meanwhile, AFRINIC was crumbling. Financial opacity, leadership voice, a dysfunctional board that failed to meet quorum. By late 2022, the CEO had been barred and the board disbanded. An official receiver was appointed to stabilize operations and oversee board elections. Those elections, after years of delay, finally arrived in June 2025. But they were disrupted, not by legal chaos this time, but by interference from ICANN. 2 weeks before the election, ICANN wrote to the official receiver, raising concerns about nomination process. They questioned the legitimacy of a new AFRINIC member, Cloud Innovation, again, and demanded the nomination committee be restructured. The Supreme Court of Mauritius swiftly dismissed ICANN's intervention, calling it inappropriate, unreasonable, and without standing. But the damage was done, the process was thrown into doubt. And when a member of the election committee improperly removed the power of attorney document from the ballot room, the vote collapsed. The official receiver annulled the entire election. The engagement letter raises multiple red flags. Why was a despot lawyer selected to handle multi-million-dollar litigation? Why use an intermediary law firm when the actual legal work was outsourced? Why prove flat, unexplained legal fees with no breakdowns or caps? And why do individuals with no legal authority still represent AFRINIC in court? Most importantly, who approved these decisions? For years, the public was told this was a principled fight to defend Africa's internet future. But this letter and the events around it reveal something far more banal. This wasn't a battle of ideologies. It was a business dispute between two companies. One of them tried to resolve matter through due process. The other prolonged the fight and appeared to profit from it. Today, AFRINIC remains unstable. The damage, reputational, structural, and financial, may take years to undo. And while the world debated sovereignty and governance, a small group quietly collected checks, hour after hour, litigation after litigation. The letter doesn't just reveal mismanagement, it suggests betrayal, not of policy or principle, but of trust.